Seconds to go. Start. The judgment deals with issues related to properties held by the joint Hindu family having several surviving co-partners, and note that of a sole surviving co-partner. He thus implored the court to accept the appeal and set aside the impugned judgments. Learned senior advocate representing the respondents vehemently and fervently opposed the submissions advanced by learned counsel for the appellant and contended that the issue in the present case regarding the ambit of the rights of a female Hindu on the undivided joint Hindu family estate under section 14(1) of the Succession Act has been settled by this court in the case of Munni Devi alias Nathi Devi dead through LRs and others versus Rajendra alias Lallu Lal dead through LRs and others. He placed reliance on the pertinent observations made by this court in Munni Devi Supra and implored the court to dismiss the appeal and affirm the impugned judgments. We have given our thoughtful consideration to the submissions advanced at bar and have gone through the impugned judgment and the material available on record. The plank contention of Shri Puneet Jain, learned counsel representing the appellant for assailing the impugned judgments, was that the deceased widow Shrimati Nand Kanwarbai was never in possession of the suit property, and as a consequence her adopted son plaintiff Kailash Chand was precluded from claiming partition of the suit property by virtue of succession, and hence the revenue suit was not maintainable. He had placed reliance on the findings arrived at by the civil court in the suit filed by Shrimati Nand Kanwarbai to buttress this contention. At the outset, it may be noted that insofar as the aspect that Shrimati Nand Kanwarbai, deceased widow, had never been in possession of the suit property is concerned, the same is virtually an admitted position from the record because she never challenged the judgment and decree dated 21st May 1959, whereby the suit filed by her for declaration of title and possession was dismissed by the civil court, and she was held only entitled to receive maintenance from the undivided estate. Thus, indisputably, neither Shrimati Nand Kanwarbai nor the plaintiff Kailash Chand were ever in possession of the suit land. In the case of Munni Devi Supra, which was heavily relied upon by the learned counsel for the respondent Shri Bhattacharya, the admitted position was that Bhanori Devi, widow of late Dhanna Lal Ji, was actually residing in the suit property during the time the co-partner Shri Hari Narayan Ji was alive, and even after his death she continued to reside in the said house and used to collect the rents from the tenants who were occupying the suit property till the date of filing of suit. A bench of two honorable judges of this court, after considering the gamut of Section 14 of the Succession Act in the case of Munni Devi Supra, observed as below. In view of the above, there remains no shadow of doubt that a Hindu woman's right to maintenance was not and is not an empty formality or an illusory claim being conceded as a matter of grace and generosity. It is a tangible right against the property which flows from the spiritual relationship between the husband and the wife. The said right was recognized and enjoined by pure Sastric Hindu law which existed even before the passing of the 1937 or the 1946 Acts. Those acts merely gave statutory backing recognizing the position as was existing under the Sastric Hindu law. where a Hindu widow is in possession of the property of her husband or of the husband's HUF, she has a right to be maintained out of the said property. Stop.